our civil contempt. We have 3 matters on the calendar this morning. I'm going to call the case. Let me know if you're here. And then for Ms. Habib, how much time, Ms. Bouvier, how much time are you requesting? Ms. Bouvier, I thought I saw, okay. I can't see you at this juncture, and your video, and your sound is on mute.
10 minutes.
So put time there.
Your Honor?
Oh. Okay, give me. All right, give me one moment. The court had an opportunity to.
Buckle up. Guys, today we are going to witness the opening of a tense courtroom showdown. Right from the start, you can feel the intensity as the judge lays down the law with no sugarcoating. London Bouyer tries to assert authority through her representative stance, but the judge makes it crystal clear. Personal responsibility is on her shoulders. The legal theater is already heating up, and the power dynamics are set. The stakes are high, and the audience can already see this is not going to be a typical procedural hearing. Every word is weighed, and tempers will inevitably clash.
To review those and has a better understanding of background. I can't remember exactly how far we got in there. I don't know if Ms. Giles even made recommendations at that time. I don't think we got that far, but I'm not sure if you all remember or not. But I have read the recommendations in the report.
I don't think we got that far last time, Your Honor.
Okay, all right. We have Ms. Bouvier. Ms. Bouvier, you need to turn your video on because we're in the middle of trial. Middle of the hearing now. So you have to have your video on. You can turn your mic off, but your video needs to be on.
Your Honor, for the record, before we proceed this matter, there are some facts I must state for the record. I'm here on special restricted appearance as the representative of the descendant. And I do not wish to waive any rights, rather statutorial or procedural. And for the record, as the authorized representative, executor, beneficiary, I have demanded a jury trial in regards to this matter.
Here's where things get technical but revealing. Bouyer emphasizes her rights and even demands a jury trial, citing Georgia law, showing she's fully prepared and has done her homework. Yet the judge methodically pushes back, highlighting jurisdictional limits and procedural realities. This part of the hearing underscores the tension between legal knowledge and courtroom procedure. It's a masterclass in how understanding the law doesn't always equate to winning in court, especially when rules of procedure override personal claims.
Moving forward, for the record, Your Honor, I have filed an amended notice of recusal with an affidavit of fact on May 29, 2024. With all due respect, Your Honor, I have not received a response from you in regards to this notice. Please note for the record, I have presented to this court on special restricted delivery all presentments to date. Moving forward, according to Georgia Code Section 1512-122 and 2020 Georgia Code Section 91138, rights to a jury trial is a reserved right. Please note for the record, at this time, I do not wish to add nor subtract anything from my presentments, and I stand behind my documents. And at this time, I respectfully excuse myself from this proceeding to await all notices concerning the trial by jury according to the law.
Okay. So first, you filed a motion for recusal, which the court denied. Looks like you filed, you need to turn your video back on. If you don't turn your video back on, I'm going to have a hearing without you.
Now, we're entering the moment of truth. The judge points out the necessity of video participation, a small but crucial procedural requirement, and Bouyer is clearly testing boundaries. This segment illustrates the friction between authority and self-representation. The courtroom isn't just about law. It's about compliance, control, and respect for protocol. Here, viewers see firsthand how procedural missteps can dramatically impact outcomes, even before any substantive legal arguments are addressed.
Okay, so turn your video back on. All right. You filed a motion for recusal, which the court reviewed and denied without there being sufficient evidence. I think you filed an amended one, which the court did not receive a copy of. You were supposed to send that to Chambers if you actually wanted me to respond to it. But you filed it via e-file. I'm noticing it now. It's going to be denied for the very same reasons. With regard to your request for for a trial, this is a custody matter. It cannot be a trial by jury because you can't have a trial by jury on a custody matter. So that issue will be denied. As for your representation, the court will consider you London Bouvier. That's who you are. That's what the court consider you as. If you want to consider yourself as anything else, that'll be up to you. But when I make a decision, it's going to be for your government name, London Bouvier. And that's what the law of Georgia is going to hold accountable. So when you don't do what I asked to do, your representative or whoever you think you might be won't be going to jail. It will be you, London Bouvier. Okay? So I want to make sure you understand that. So is that clear to you? All right, we're going to proceed in these proceedings. If you want to participate, that's up to you. If you don't want to participate, that's up to you. But I am.
Bouvier presses forward with her arguments, citing affidavits and notices, insisting her rights are reserved. Yet the judge calmly dismantles the possibility of a jury trial, explaining custody matters can't be tried by a jury. This part is eye-opening because it highlights the gap between personal interpretation of rights and what the law practically allows. The tension is palpable as the courtroom becomes a stage for legal strategy versus procedural authority.
I'm going to make a ruling, and the law will be what the law is. I suggest you should participate so that you can be heard, and that the concerns that you have, the court will have an opportunity to hear them. That'll be up to you, okay? But if you do participate, you need to have your video on. Ms. Giles?
Yes, Your Honor.
Start with your recommendation first, and then you can back up with why you made such decision.
Sure. And I think we're just here on the limited matter for contempt from that interim order that was entered in April, if I'm correct. And I agree with that, what's in that order, Your Honor, as far as getting visitation started from Elaine and Dad.
Yeah, hold on. Let me pull back for a second, okay? Because I think I had to go to another. Okay, so I see on April 19th, amended parenting plan.
No, Judge. We had the hearing, I believe, on the 14th. We submitted an interim order for a temporary visitation that was signed on the 19th.
Yes, signed.
The judge starts to assert firm control, reminding Bouvier that her government name will be the one recognized in court. Here, the courtroom drama intensifies. Authority is clearly being exercised while Bouvier struggles with self-identification and formalities. Observers can see the balance of power shift as the judge warns of real consequences if protocol isn't followed. This is a moment where preparation meets the rigid reality of legal procedure.
On the 19th.
That's correct, Your Honor. I'm sorry, it was signed on the 18th and filed on the 19th.
Did you get a copy of it? Obviously.
Yes.
Yeah,
Okay, I don't see it. Hold on for a second. Did you see it in the?
Yes, ma'am.
It's not showing in Judge's edition.
Oh,
That's odd.
it is.
Odyssey shows it.
Yes, ma'am.
Okay, I apologize. So there are two things. There's Odyssey that everybody kind of looks at, and then there's Judge's edition, which is how we keep our notes based on a document, which is how we operate. I don't know why, but this interim order isn't there. So when I was reviewing the file for this hearing, I didn't see this order. So let me take a quick second to look at it. Thank you.
No problem, Judge.
Has this order been followed? Is it being?
Yeah, Your Honor,
Yeah.
that's why we're here.
It's not being followed.
No, right. We filed a contempt on this order on May 7th.
Really? I don't know what's happening. Okay.
Contempt warnings escalate the tension to a boiling point. Bouvir's repeated refusal to turn on her video becomes a tangible trigger for legal consequences. The judge outlines the severity minus 10 days in jail and temporary custody of the child will transfer if compliance isn't met. This part is compelling because it demonstrates how courtroom etiquette isn't trivial. It's enforceable and carries real-world consequences. The drama here is both procedural and deeply human.
I had thought that this matter was coming back on the calendar because I continued it from the last matter, but now I understand. Okay, so there is also the contempt on the interim order.
That's
All right.
correct, Your Honor.
Got it. I got it. All right. Yeah, all other issues shall remain. Okay. All right. So the order isn't being followed.
That's
It is
correct.
not.
That's the issue. It being followed at all, like no visitation, or just being.
No visitation at all, Judge.
All right, Ms. Bouvier, I've indicated to you once before that your video has to stay on. This will be my last warning to you. Turn your video on. Ms. Bouvier, if I say it again, I'm going to find you in contempt of court. If I say it again, I'm going to find you in contempt. So when any issue happens before, I'm going to have my deputies come get you. Okay? You turn it off again, I will find you in contempt of court. All right? So you will spend 10 days in the DeKalb County Jail. You turn the video off again. Okay? Did you understand me, Ms. Bouvier? Did you understand me, Ms. Bouvier? Unmute yourself and say so. Ms. Bouvier, I'm going to ask you one more time. I'm going to excuse you from this hearing. I'm going to find you in contempt, and I will pick you up. And your child will then go to Mr. Habib. Unmute.
I stand behind my documents. For the record, I stand behind my documents.
You can stand behind whatever you want. Do not unmute like I asked you. Ms. Marshall, go ahead and remove Ms. Bouvier from these proceedings.
Yes, ma'am.
I find you in contempt of court. 10 days in the DeKalb County Jail. Child will be presented to Mr. Habib. These matters will be continued thereafter. All right.
Thank you, Your Honor.
All right. You all have a good day.
You too, Your Honor.
All right.
Judge, do you want me to prepare an order for instance?
Prepare the order. Put it in Word so I can put in my contempt. But interim the custody of the child will be sent to Mr. Habib.
Thank you, Judge.
All right.
Thank you.
We see the ruling and the enforcement of authority. Bouvier is removed, contempt is officially noted, and temporary custody of the child is clarified. The courtroom demonstrates how law, procedure, and authority intersect under pressure. Viewers get a raw look at the consequences of non-compliance and how the court manages control and fairness simultaneously. This conclusion is both a cautionary tale and an insight into the rigor of legal enforcement.